Over to you, Mr. Blake.
Thank you, sir. Moving on to the case of Angela Sefton and Anne Neild, could we please look at poll 00113343, please? This is returning to the Court of Appeal, but now we're in a different Court of Appeal case, the case of Roger Allen and others. Could we please look at paragraph 23? It's on the fourth page. And if we scroll down, we can see the cases of Angela Sefton and Anne Neild. Paragraph 23. Thank you very much. I'm going to again read briefly from the transcript to refresh our memories as to this case. On the 11th of April 2013, the Crown Court at Liverpool, Angela Sefton and Anne Neild each pleaded guilty to one count of false accounting with which they were jointly charged. The allegation against them was, in short, that between the 1st of January 2006 and the 6th of January 2012, they had falsified gyro deposit entries on Horizon in relation to the receipt of £34,000 in donations made to the charity Animals in Need. On the 13th of May, Ms. Sefton was sentenced to 6 months imprisonment, suspended for 12 months. Ms. Neild was sentenced to 5 months imprisonment, which was also suspended for 12 months. If we scroll down to paragraph 27 and 28, please. The Post Office audited the branch on the 6th of January 2012. During the audit, 40 gyro deposit slips and a number of cheque envelopes were recovered from a cupboard which showed suppressed deposits in the sum of £34,000. Ms. Sefton and Ms. Neild handed the auditor a jointly signed letter in which they said that they had tried to repay shortages by using their own credit cards and holiday money. They eventually ran out of funds. As a result, they began to cover up shortages by delaying the processing of business deposits to Santander and one other bank. They could not explain the shortages. They had reached breaking point in their lives and health had been deeply affected. On the 20th of January 2012, Ms. Sefton and Ms. Neild were each interviewed. Ms. Sefton said that they had only ever delayed payments and had never withheld them. Animals in Need had been significantly affected. If we scroll over the page, it says she and Ms. Neild did not report the losses because they were too terrified. It appears that Ms. Neild gave a broadly similar or at least consistent account. She said she did not know where the shortages were coming from. Both submitted defence statements which questioned whether the losses were genuine or Horizon generated. They requested relevant disclosure and access to Horizon for the purpose of examination by a forensic accountant. Solicitors on behalf of the Post Office asserted that material relating to Horizon was not disclosable because the case turned on the deposit slips which formed no part of Horizon. Ms. Neild repeated the disclosure request with the result that the Post Office agreed that a defence expert should be allowed to attend the branch to analyse the data. The Post Office served a witness statement by Gareth Jenkins in which he maintained that there was no problem with Horizon. Call logs show that some difficulties with Horizon had been sporadically reported to the Post Office between 2005 and 2011. Other records show numerous difficulties with Horizon in 2009. The Post Office accepts that this was an unexplained shortfall case and that evidence from Horizon was essential to the prosecution of both Ms. Sefton and Ms. Neild. Post Office failed to carry out a proper investigation into Horizon issues and failed to disclose full call logs and other records indicating that there had been problems with Horizon at the branch. In addition, Mr. Jenkins had informed the Post Office solicitors that he had no information regarding complaints or investigations into Horizon, and it has already been established that it's not possible to examine the original Horizon system that was operational until 2010. Similarly, I've not been presented with any audit data relating to any of these cases to examine. These defects in Mr. Jenkins' evidence were not disclosed, nor were two earlier relevant reports disclosed. In those circumstances, the Post Office accepted that their prosecution was unfair and an affront to justice. Can we please look at poll 00328743? This is the audit report into their branch, the Fazakerley branch, and it says as follows. Fazakerley is a busy branch in the suburbs of Liverpool. We have visited this branch more than any other branch during the last few years and always find it to be well run and welcoming. On the 6th of January 2012, accompanied by my colleague Richard Cross, I conducted an audit of the above-named branch. Also present were Steve Bradshaw and Kevin Ryan from the security team. Just pausing there, we have 2 auditors, 2 investigators arriving at the branch on the 6th of January 2012. Why was it necessary for 4 people to attend that branch?
The audit was put on. The auditors arrived before that. Me and Mr. Ryan, we attended because of the audit to be put on, because Miss Sefton previously telephoned me to say that she wanted to speak to me.
Yes, but
and that's why we attended. It's normal for the auditors to attend to audit the branch while we looked into this customer complaint from the Animal Needs charity.
So is it normal for 4 individuals to attend what is a relatively small branch?
We went there to do it. 2 were there to do the audit. We were there for the inquiry regarding the non-sort of the cash deposit slips that weren't being credited to the customer's account.
And it says this was a special request audit by the security team, and the purpose of this audit was to verify financial assets due to the post office. The audit revealed a surplus in the branch, etc. If we go over the page, it says we arrived at the branch at 8:15 a.m. and introduced ourselves to a member of staff on the shop counter. She referred us to the post office counter, where a member of staff was sat in the dark behind the counter. I knew this was one of the members of staff I had previously met, but she was not her normal welcoming self. The other members of staff arrived at 8:45 a.m. and she was slightly upset. As I had very little information of why we were completing an audit so soon after a similar audit, I told them that and advised that we were there to perform an audit on behalf of the post office. They told me that they knew why the audit was happening and that they were sorry for causing us problems and sorry for misleading us at previous audits. In brackets, there were tears. Do you remember them being in tears when you were there?
No, I don't recall them being in tears at all.
Do you remember them being upset?
I would say that they didn't seem particularly upset. They had contacted me, even on the day of the audit. Miss Sefton phoned me to inform me the auditors was there, and I told her that it was coming down to the branch shortly.
Do you have any reason to doubt what the auditors reported?
No, when they arrived, no, I have no reason to doubt what they said.
At around 11 a.m, Steve Bradshaw asked us to check around the branch as the staff had told them that they had concealed some transcash paperwork in the cupboards. We spent about 10 minutes looking but couldn't find anything. One of the staff members was led through the secure area and immediately located the paperwork, which she handed to Steve Bradshaw. The staff agreed to leave with the security team, and before they left, they were allowed to collect any personal items from behind the counter. Again, they apologised and said sorry for all they had done and that they felt terrible. Was that your recollection as well, that they were apologising, felt terrible?
Yes, Miss Sefton and Miss Neal apologised sort of all the way through, and it was Mr. Ryan who went with Miss Neal to recover the deposit slips, and he brought them back. He counted them up, and he was 40, that was, give or take a bit, the £35,000.
And was this again a case where you were the lead investigator?
Yes.
Yes. Can we please look at poll 003287734, please? The second email on the page is an email from yourself to Andrew Boltz. I believe he was, we've heard from him, he was a lawyer at Cartwright King. And you say as follows, on another point regarding the case of Bramwell, has the court decided anything regarding the trial date? Also, in light of the Post Office instructing independent experts to look at the Horizon system, would this have any bearing on the case? The reason I ask is that one of the witnesses would like to book some leave, and the date in question is the 13th of August. This is an email in the context of the case of Sefton and Neald, but you're referring to another case, the case of Bramwell, and you're raising the issue of independent experts having been appointed. Is that second site?
It probably would have been at the time. The Bramwell one was is a case that was allocated to the South team, and there was a big change in the South team when most of them left, and I ended up with their cases. I was not involved in any of the interviews or the investigation of the South team ones, but I had to liaise with the solicitors and the courts to follow the due process.
But as at June 2012, you were aware that the Post Office had instructed independent experts to look at the Horizon.
Which is second site, yes, I think.
And if we scroll up to the response from Mr. Bolts, he says, in the context of this particular case, John is away and he gives you certain weeks, days to avoid, etc. And then he says, my understanding is that the Post Office line remains that the system is a robust one. The defence could presumably raise the issue, but have not done so yet. Do we know when the review is going to conclude, as this could affect the judge's decision to adjourn for this reason? Mr. Bolts is there saying that that is the Post Office's line. That's not particularly reassuring, is it, in terms of the reliability?
Not at all, and he would be more likely to know when the review would conclude rather than myself.
But in terms of the reference to the Post Office line and an email to yourself, did that cause you any concern that it seemed to be a line coming from the Post Office rather than, in fact, the correct position?
Yeah, as I say, that's come from them. I was just at the very end of the Bishop's Road, the Bramwell case, the one underneath London Road, Sunningdale. That I was just sort of like a liaison for these. Everything's just sort of go in, and I just say, yes, to me, it shows that Mr. Bolts knew about the issues and should have taken it up accordingly, if he felt.
But it also shows that you were aware of a corporate position, a particular line that's being taken by the Post Office.
He's informed me, but as I say, these are all cases that were well ongoing, and I was just a liaison man to sort out the very end. If the South team hadn't changed, them emails wouldn't have even been on there.
Mr. Bradshaw, you weren't a liaison man. You were the investigator
I wasn't.
charged with investigating
No,
Sefton and Neild case.
Yeah, correctly for Sefton and Neild.
So at this particular time, you were investigating a particular case in relation to discrepancies on Horizon, and you were aware that there was a Post Office line that the system is a robust one.
In there, but also, as I said before, about taking it into context, the context of this one was to do with people's, whether it be a private individual, a business, the treasurer of the charity. This was all to do with cash deposits not being credited to that person's account. That's the inquiry I was looking into.
But weren't you also looking into the fact that these people were complaining or concerned, in tears, etc., that they had discrepancies that they couldn't account for? As
I said, there was no tears, but Miss Sefton handed me a note on the morning explaining fully what they had done, how they withheld the gyro slips. They withheld them ones because they were the last, I think, business where they used deposit slips. My inquiry to look into was the non-credit of gyro of people's cash deposits.
We have an audit report that says that it's always been a well-run and welcoming branch. You have the sub-postmistresses, assistants, etc., very concerned about a discrepancy. You have Second Sight carrying out their investigation at this particular time. Did you not think to yourself, maybe I should think about wider problems with the Horizon system?
If they've shown all paperwork is correct, the balance, like there, the balance is correct. They show the surplus of £559, but in reality, it should have been £34,000 short if them deposits had gone through. If it's not reported, it's very difficult to try and find something that isn't there.
But their very case was, we have these discrepancies, we don't know how they're arising, we've had to cover them by delaying those other payments.
That's what they've said in their mitigation of why...
It's not mitigation, though, it's actually...
It is.
Their account.
No, in there, that inquiry was about the non-credit of deposit slips. That's what I looked into initially. That any losses that they couldn't tell me, I lost money this time, I lost money that time. They did bring up in an interview where it's something to do with a £4,000 loss, but that was something between them and the postmaster some 5 years earlier.
If you were told, as at 2012, that there was a software bug that caused their significant discrepancy in their account, and you had been told by them that they had been trying to cover that up, would you still have prosecuted them?
They were prosecuted for the gyro deposit slips not going in.
And if you were sure that the underlying problem was a bug, error or defect in the Horizon system that caused that discrepancy, would you still have prosecuted them for covering that up?
That's not my decision. That decision would be made by the criminal law team or Cartwright King.
Did you not think that that was something worth investigating?
Not in this inquiry. This inquiry was solely about the non-receipt, the non-credit of people's money being paid into their account, which ultimately caused the charity to have difficulty with their cash flow problems. That's the inquiry I looked at.
Did you not think about looking into the reasons for that discrepancy?
The discrepancy was quite simple. They did not when the customer come in to deposit money, they did not deposit the money. That was the inquiry. Whatever happened before, as I say, to use the word mitigation, they haven't brought up and say this happened on this day. They just said they were covering up losses, but no substantiation with it. The inquiry was solely about non-credit of people's money.
You were aware that an important part of their case in the criminal proceedings was that the underlying discrepancy was caused by bugs, errors or defects in Horizon.
That's not in this case. This case was solely that they did not credit somebody's deposit. You as an individual, me as a business or somebody else as a treasurer, they've made the complaint saying I'm paying money into a post office and it's not in my account. That's what was looked into on this occasion.
Can we look, please, at POL 000444036, please? We've seen defence statements in other cases. This is the defence statement in Miss Sefton's case. This is produced by her in defence of the criminal proceedings that were brought against her. Can we please look at paragraph 5? It's on the first page, the bottom of that page, please. 18th of July 2012. She says as follows: the defendant asserts that significant shortages/losses had been a common experience in the past. Losses started to occur from 2005. The defendant had to make good a great deal of those losses out of her own pocket, but as the losses increased, the defendant could not afford to repay them from or her own resources. Over the page, please. If we could scroll down to paragraph 11. The defendant also praised in aid of her defence the fact that the Post Office's computer system, known as Horizon, installed sometime in 2005, has been the subject of criticism in the press. A firm of solicitors in the Midlands, Shoesmiths, are acting on behalf of 100 sub-postmasters who in the past have wrongly been accused of fraud and false accounting and have been compelled by the Post Office to repay significant sums of money or face criminal prosecution, presumably. At the heart of their complaint is the fact that the Horizon computer system is to blame for these apparent losses due to some form of technical malfunction. And they continue down the page, the bottom. They seek details of any complaints made to the Post Office regarding the operation of the Horizon computer system from 2005 onwards, and details of the steps taken to deal with those complaints. Over the page, please, paragraph 4. It is believed that certain members of Parliament have become involved on behalf of their constituents and possibly on behalf of complaining sub-postmasters, generally in connection with the apparent problems arising out of the Horizon computer system. And therefore, disclosure is sought of a list of those MPs. This would be of great assistance in enabling the defendant, through her solicitor, to contact them and obtain further information as to the present state of play in the investigation of those complaints by senior officials in the Post Office. I'm going to take you now to Ms Neild's defence statement. That is at POL 000444042. At the bottom of this first page, Ms Neild says as follows: the defendant accepts that the losses were shown on the Horizon computer system from 2005. The defendant does not know how the losses were incurred, the defendant now believes that such losses may have shown as a result of failures in the Horizon computer system. If we scroll over the page, there's a request for disclosure. The defendant requests disclosure of the following and see details of complaints and investigations into the Horizon computer system. Could we please turn to POL 000583300? And it's page 8, please, that I'd like to look at. Is it fair to say that from those defence statements that we've seen, the Horizon system, the reliability of the Horizon system was front and centre of their defence?
That's what they're indicating. But however, they weren't having permanent shortages because the audit showed a surplus. And as I've explained, this inquiry concerned the non-credit of deposit slips. That's the initial inquiry, what we were looking at.
So you didn't think that it was necessary to look beyond your case and look at their defence and look at the allegations they had made about the Horizon system and provide them with disclosure as to issues with the Horizon system?
I can't explain it any other way. The inquiry was about the non-credit of people's cash deposits. The other is a second issue of why they committed that offence. And
for you, that didn't matter?
I'm there to gather the evidence and pass it to the solicitors. They still committed the offence. Well, Miss Sefton gave me a note explaining fully what they'd done, why they'd done it.
Did you consider it necessary to pursue reasonable lines of inquiry in respect of a defence case that somebody had raised?
The inquiry concerned the non-credited thing, and every line of inquiry was done regarding somebody not being credited with the cash that should have been deposited some weeks or months earlier.
And no lines of inquiry went to the reliability of the Horizon system?
The Horizon system is another issue.
Well, it's the central issue in their defence statement. That's why I'm asking.
But again, they're saying they've had that, but they still committed that offence of not crediting the gyros.
And for you, the reasons for the discrepancy was simply irrelevant?
No, not at all. They say it's losses, but it's very difficult to try and find the losses. They make the paperwork and the accounts look correct, as shown with the audit on the day. That was £550 surplus.
One of the aspects, one of the things that people will think about when they're deciding whether to charge somebody with a criminal offence is the public interest in pursuing that charge. Do you think the reliability of the underlying system that causes a discrepancy of a significant value, do you think that is important for considering the public interest in pursuing a criminal allegation?
The public interest in this case is that charity did not get credited with nearly £35,000 of people's money that they've donated to it.
And you can close your eyes entirely to the reason for that?
That's their rationale, but it doesn't affect that inquiry of the charity not being credited with £35,000 over a period of time.
Did you see any burden on yourself as the investigator to pursue those lines that had been raised by the defence in that case?
As I said, that's mitigation. They said they've committed that offence because they were having losses, but because they never said I had a loss at this day, because they're making the paperwork correct.
If they were making the paperwork correct because a significant discrepancy had been caused by the Horizon system that the Post Office had put into their offices, would you still have pursued a criminal prosecution?
That's on the advice of Cartwright King. The inquiry was done based on gyro deposits from people, members of the public, donating to a charity, not being credited to that charity. That's the line Cartwright King had taken.
You were the investigator in the case. You must have had a view. Did you have a view? If, for example, it could be shown that there was a significant discrepancy in that branch caused by the Horizon system, would you not have offered a view as to whether it's in the public interest to prosecute that case?
I've explained. In this case, the public interest is the people not getting their funds, what they've given to the charity, credited to the charity. Can't say anything further. That's another. That's their mitigation, as I keep using, that they were having losses, but I'm unable to try and find what the losses were. They couldn't tell us they had a loss on this day, that day.
So the cause of a discrepancy would not feature in the assessment as to the public interest in prosecuting a case.
As previously explained to you, everything has to be taken into context.
Can we look at page 8 of this document that we're currently on, please? It's a letter from Cartwright King to Miss Neild's solicitors. If we scroll down, please. Disclosure of prosecution material under Section 7 of the Criminal Procedure and Investigations Act. I have considered your defence statement dated the 9th of August 2012. Under Section 7, I am required to disclose to you any prosecution material which has not previously been disclosed and which might reasonably be expected to assist your defence as described in your statement. On the basis of the defence statement that you have provided, I have not identified any further prosecution material which is disclosable to you in accordance with the CPIA. Over the page, it says as follows: your client is charged with false accounting by failing to make entries onto the Horizon system regarding the deposit slips found, and thus the offence has occurred outside of the system. Material relating to the Horizon system is therefore not deemed disclosable at this time. Was that something that you therefore agreed with?
That's, but as I said, the lawyers are the ones that do all disclosure. Whether I agree or disagree with, that's the lawyers doing sort of that. My understanding and my way would be that whatever you have, you disclose. That's up to the lawyers.
Did you, as at the date of this letter, pass on to the lawyers any concerns that you had about the reliability of the Horizon system?
I would say no, because the lawyers would know of any concerns that are involved in the Horizon system.
We'll see that in Ms Neild's case, the solicitors pushed further and they made an application for disclosure. Can we please see POL 000444041, please? Thank you. If we could scroll down, it sets out the application. It says, the defendant has sought and been refused disclosure of the following: details of complaints and investigations into the Horizon computer system, access to the system used by the defendant. If we scroll over the page again, onto page 3, please. There are submissions within this application. Paragraph 15 and 16 and 17. It's submitted that material which suggests that the Horizon system has accounting faults is therefore relevant to and of potential assistance to the defence for the reasons outlined at paragraphs 12 to 14 above. It is submitted that access to the Horizon system by a defence forensic accountant is necessary. Furthermore, if a forensic examination of the Horizon system used by this defendant reveals that the losses were incurred as a result of computer error, it may be that the prosecution review the decision that pursuance of this case is in the public interest. And that's the point that I was making before, that might it not be relevant to the public interest as to whether there was a problem with the Horizon system.
And I fully accept what you say, but also the public interest is you have a charity where donations have been given and they have not received them over a period of weeks or months, which caused cash flow problems for that charity. The charity made the complaint, and that's why an inquiry was raised.
Might there be a number of different public interests to take into account?
No doubtedly there would be, depending on which person of the public is looking at it. People who give readily to charities and whatever would probably find it that maybe they should be prosecuted because their hard-earned money is going over and not being credited to the charity. Other people may take your view.
You're the prosecution authority in this particular case. Did you not think it worthwhile casting your mind to that particular public interest?
I am not the prosecution authority. I gathered all the information and passed it to the lawyers. They decide whether a prosecution ensues, not me.
Can we please bring up onto screen your witness statement again, WITN 044501000, and it's page 12, paragraphs 42 to 44. This is what you've said in relation to this case. I've been asked to set out my recollections of these proceedings and been referred to a number of documents. This inquiry concerning suppression of deposit dockets was assigned to me. On the date of the audit, the letter was handed over, which had been jointly prepared by Ms. Sefton, Ms. Neild, stating they had been withholding customer deposit slips. The slips had been kept in a cupboard behind the counter. There were no concerns. The investigation was conducted in a professional manner at all times. I have no other reflections about this matter. In light of our discussion just now, do you have anything that you would like to reflect on in this particular case?
Concerning that inquiry, as I have explained, it sets about, as it says in there, the suppression of cash deposit slips. I can't say no further than that. That's what the inquiry was about.
So are we to take it that you have no further reflections about this matter?
If you wish to take it that way, yes.
Going to move on to the case of Grant Allen. Can we please look at RLIT 0000039, please? Thank you very much. We're back to the Court of Appeal. This is another appeal. We've got Grant Allen named on the front of this particular, if we scroll down, sorry, thank you. Could we please turn to page 4, and I will briefly read from the judgment in his case. I think you were the lead investigator in Grant Allen's case, is that
Correct.
right? Paragraph 16, please. We have there, Mr. Allen pleaded guilty to a single count of fraud. The particulars of the count were that he falsely represented that his branch had more cash on the premises than was actually the case, resulting in a shortfall of £11,000. He pleaded guilty on the basis, accepted by the Post Office, that he could not account for the loss, but admitted covering it up. If we go over the page, please, to paragraph 18. Thank you. It describes his account. It says he gave a detailed description of his financial difficulties, which had been caused in the main by the relocation and refitting of his branch. He described inexplicable small losses, as well as some large losses, which had been attributed to one member of staff. He denied that he had stolen any money. He expressed a willingness to repay the loss, but disputed that the sums represented actual loss to the Post Office, and maintained that they had been caused by issues with the system. A number of logs retained by the Post Office demonstrate that he reported the relocation problems and his concerns about faults with Horizon. During the course of criminal proceedings on the 2nd of November 2012, his solicitors requested disclosure of an independent review of the Horizon system, believed to be the second site report. The Post Office's agents, Cartwright King, responded by indicating the review was still pending. Cartwright King stated that on receipt of the report, the Post Office would consider their continuing duty of disclosure and provide a copy if appropriate. Paragraph 21 says, the Post Office served a witness statement from Gareth Jenkins. Mr. Jenkins stated that he had been shown extracts from Horizon reports from which he had concluded that there were communication difficulties with Horizon. He stated that, provided all operational processes were properly followed, no data should be lost. Mr. Jenkins made clear that he had not seen detailed logs to see whether Horizon could be responsible for the losses at Mr. Allen's branch. He concluded that Horizon will accurately record all data that is submitted to it and correctly account for it. Correspondence between Cartwright King and Mr. Jenkins indicates that Cartwright King instructed Mr. Jenkins not to analyse the detailed logs in order to avoid incurring additional costs. In paragraph 23, it says, none of the evidence that is now available suggests that the Post Office made any disclosure relating to Horizon reliability or that it provided Mr. Allen with branch data. The evidence to prove the existence of a shortfall was wholly dependent on horizon reliability. And over the page, in these circumstances, the Post Office accepts that the prosecution was both unfair and an affront to justice. Can we now look at the offender report? It's POL 000894464, please. Am I right to say that this report was written by yourself?
Yes.
Yes. Looking at the final page, it's dated the 1st of May 2012. Can we please go to page 2? And it says there an audit was undertaken at the branch on Thursday the 2nd of February 2012 and conducted by Richard Cross, Field Support Advisor of the Network Support Field Team. Mr. Cross was accompanied by his colleagues Rob Lyon, Jane Timms, Paul Hayhurst and Tim Gordon-Pounder. The purpose of the audit was to verify the assets due to the Post Office and confirm compliance, etc. We have there 5 names of individuals. Again, is it your evidence that it's not unusual for a large number of people from the Post Office to attend individual post offices?
For an audit, it depends on the size of the branch. So there's some branches that may only have 1, some 3.
Does it strike you as unusual to have 5 people attending?
As I say, it's about the size of the branch, and that will be done by the audit team. They will take into account the amount of stock, cash and stock, that's in the branch, and they will put the number of people accordingly to get it done as quickly as possible.
Could we please turn to page 4? And it sets out there a summary of the account and interview. I'm going to briefly read from that. It says, Mr. Allen said that they relocated in March 2010 and the cost of the refurbishment and other costs amounted to £100,000. He further said that during the first 4 weeks after the move, the branch was not running at full capacity as the works carried out by ROMEC were not up to standard and a number of terminals had been wired incorrectly. Mr. Allen said that between the period of November 2009 and March 2010, he had to make good losses in the region of £1,400, and this amount can be seen in his business accounts. Mr. Allen explained that during the period of March 2010 and April 2010, there was a discrepancy in the accounts of £3,000. He said that he had checked all the paperwork but could find no explanation for this discrepancy. He then made admissions that this £3,000 was never made good and had been rolled over from each branch trading period to the next until the audit took place in February 2012. Mr. Allen's explanation for this discrepancy was that due to the relocation of the branch, the Horizon system was not communicating, i.e. polling, and the data on the Horizon system was not being sent. Could we turn to page 8, please? We then have your analysis. It says, post-interview, the non-polled report for the Horizon system was requested after the branch relocated. The report shows that an engineer attended. The engineer completed a base unit build and BT fixed a fault. It has a copy. A telephone call was also made to the branch confirmation team, and they report that they had not been contacted in relation to any £3,000 discrepancy. The call logs were also requested from the National Business Support Centre for the period. No calls are listed in connection with any discrepancies at the branch. Now, there's no reference there to the Horizon System Help Desk. If somebody had a software issue, or in this case a polling issue, so possibly a connectivity issue, we've heard evidence that it is the Horizon System Help Desk that you should be calling, not the MBSC.
My understanding at this time, when Mr. Allen relocated, there was issues with building the base units. Well, it's something to do, I think it's something like, you know, the wires that you DSL, what you link, like your telephone wires. But there is a property project manager who would oversee all that. By the time it was done and he was up and running and working, my understanding everything was working correctly.
That was your understanding.
That's my understanding.
And now you're carrying out an investigation into a very serious matter, and you have requested from the MBSC certain call logs. Did you think about requesting call logs from Fujitsu?
As I said earlier, at that time, that's when my understanding was that you'd request the call logs and you get them all. But again, in there's been no calls to report any discrepancies on Mr. Allen's own admissions.
And in terms of software problems or hardware problems, the MBSC wasn't the correct hotline to call. Are you saying that you weren't aware of the difference between the two at that time?
At that time, I don't think I was, between the call logs, one or the other. Eventually, as discussed previously, that we knew that Horizon call logs come from Fujitsu and called another way.
Thank you. Can we please look at poll 000893880? This is an email from yourself to Andrew Bolts, dated the 12th of December 2012. Sorry, if we could actually start on page 3. Bottom of page 2 onto page 3. It's an email from Andrew Bolts to you. If we could scroll down a little bit more. Thank you. This is to Gareth Jenkins, and he says, "Dear Gareth, I've just spoken to the solicitor for Grant Allen." It's about a relisting. He says, "I attach an extract from Mr. Allen's interview. As in the case summary I sent you, he's trying to suggest that an initial loss of £3,000 is attributable to lost data which had not reached head office because of installation problems. Are you able to comment on this scenario at all? Ultimately, we would need to discredit this as an explanation that holds any water. He denies stealing subsequent losses, and therefore any implication may be seeking to blame the system for those losses as well." Do you think that it was appropriate for Mr. Bolts to email Mr. Jenkins to say that ultimately we would need to discredit the defendant's allegation?
Again, whether my opinion says right or wrong, in this way, that's Mr. Bolts' way of speaking to Mr. Jenkins. At that time, I only got sight of all this when it's finally come to me at the top end of the email.
Yeah, so it's an email chain that you received the entire chain.
Yeah, I'm right at the end of the email chain.
Let's look at the one email above that to begin with. A response from Gareth Jenkins to Mr. Bolts. And he says as follows: "I think I understand what he is claiming. However, where there are comms problems, it's normal to recover any missing data once the comms are sorted out. So this shouldn't be a reason for a loss. Also, there are processes in place to retrieve outstanding data where there are extended comms issues lasting more than 7 days." He says, "I could just make a general statement relating to that, or if we retrieve data from the time, I could check out exactly what happened in this case." He continues, "I've checked with Penny," I think that's Penny Thomas,
I think so, yes,
"in our prosecution support team, and Post Office Limited have not requested any audit data relating to this case. She's checked back as far as April 2010. Nor have we been asked about help desk calls, which would probably have occurred if there were comms issues. Is it worth asking Post Office Limited to request such data for me to examine before putting together a specific statement for this, or is a simple generic one sufficient?" Just pausing there, is this the email that caused you to think about the differences between the MBSC?
I can't say for certain, whether it's just been a conversation with other members of the team. You suddenly find when you were asking for call logs, and you go where's my Horizon logs? What's this? And then you find you have to go a different way. And when we requested Horizon call logs, it always went via the casework team of the security team.
It continues, "Note that the data retrieval is part of the standard service that Fujitsu provides to Post Office Limited, but any time I spend examining the data, say a couple of days, would be chargeable to Post Office Limited, and so there are commercial considerations for you or Post Office Limited to consider. As we're nearing the Christmas break, I cannot commit to doing any such analysis before the new year. Were you aware of commercial considerations and concerns about having to spend money on Fujitsu's assistance?
There's always been commercial concerns because I think part of the contract was you got so many, when you're requesting the ARQ data, there were so many sorts of like free ones anymore. So you would look at what data is required, because sometimes you might get a blanket, I want 5 years worth. And you have to look at the consideration of that. However, if it's required for the case, the cost does not come into it. If it's needed, it should be applied for.
If we scroll up, we then see a response. Mr. Bolt says as follows. He says, "Thank you for considering the position so promptly. I can now confirm that the case has been put back. I would appreciate if you could add your general comments at this stage regarding the safeguards in place for comms problems to your statement, and send this to me as before, and I will refer back to the Post Office to consider whether we go on to request the retrieval of data for your further analysis. I say so on the assumption that the data is available for 7 years. An idea of what 2 days analysis would cost would assist in that decision." Just pausing there, why would the cost assist in the decision as to whether to seek the data or not?
I can't say for that. That's between. I'm not subject to the party to all this about costs backwards and forwards. That would be solely between them.
Mr. Bolts would have, of course, had to have taken instructions from the Post Office.
From the Post Office, not from me.
Who would provide him with instructions on
Probably
costs?
whether it be the casework team, someone. It wouldn't be taken from me.
He then says, with regard to help desk calls, I also assume that this information available freely to the Post Office, and therefore would request that inquiry is carried out. I attached the Horizon non-polling report obtained by the investigator in this case previously. Could we scroll up to the very top of this chain, please? Mr. Bolts emails you and says, please see the attached report from Gareth regarding this case, which I propose to serve on the defence. I had asked him to look at the non-polling issue raised in Mr. Allen's interview, and I believe that he has dealt with it adequately for our purposes. Gareth tells me that it is in fact possible for him to retrieve the actual data from this time to see what actually occurred at this branch, and that the retrieval of the data is free to the Post Office. However, he estimates that it will take approximately 2.5 days for him to look at it and analyse what it means, and this would be chargeable to the Post Office at £2,500 approximately. I have told him that at present we do not wish to pursue this option unless it became unavoidable. Can you let me know your thoughts before I get him to sign it off? This is an email to you from Mr. Bolt, just the two of you involved in this. Why, if you're not responsible for making decisions about the cost of retrieval, is he asking you whether to pursue that route?
I don't really know, but in the case for this email, it would either be replied to via an email back to him or a telephone call. But as I said, if it's required, that the data is required, 2,500, while it sounds a lot, in the greater scheme of things, it isn't. And if it's required, they have to go ahead with it. It's almost.
And was that your answer to Mr. Bolts, that if it's required, it's required? I don't care about the cost.
Basically, that's my stance on it. It's as if he's trying to put it on me to sort of say, oh, it's too there, don't bother with it. But my stance is, if it's required for any inquiry or prosecution, you have to get it.
And it's your evidence that you clearly communicated that to Mr. Bolts?
Yeah, because if I've been asked to do something, you know, I don't know how the communication's gone back, whether it's been an email or a telephone call, but I would have answered them. I do not let things just go off as if it's going to be buried away. I will have answered them.
Can we look at poll 000898380, please? This is the response to this particular issue from Mr. Bolts to Mr. Jenkins. Sorry, it's FUJ 00153884. He says, "Dear Gareth, the investigator is happy with the report as it stands. Please could you proceed as before?" So absolutely no questioning there that further investigations, further data was going to be obtained. It implies that you, the investigator, was happy as it stands.
I can't explain how he said that. As I said, it indicates that I have spoken to him about it, but whatever the conversation is, I can't say at this time.
Well,
It's whether it's, whether it's me towards him or him towards me. So I think he's made the decision in the end. My stance would always be that if it's required, irrespective of the cost.
why isn't that reflected in this email?
I can't speak for Mr. Bolts. I don't know.
He says the investigator is happy. You were the investigator. It says the investigator is happy with the report as it stands.
And that probably it could well be based on whatever he's explained to me.
Mr. Bolts has given evidence to this inquiry. His suggestion, in fact, was that the investigator, the words the investigator, was essentially in speech marks because he didn't think that you were much of an investigator.
Well, that's Mr. Bolts' opinion.
And what are your views on his opinion?
Well, I could say the same about Mr. Bolts, but I'm not going down that line. That is the thing. That's Mr. Bolts. If he wants to say that, that's fine.
You say you can say the same about Mr. Bolts. What
Yeah.
was your opinion of Mr. Bolts and his abilities?
Mr. Bolts was a lawyer for Cartwright King.
And what was your view?
I'm not prepared to get into somebody's character.
Well, their abilities to carry out, for example, effective inquiries and effective prosecution is important in the context of this inquiry. So we would be grateful for your views on Mr. Bolts and his ability to carry out the job that he was tasked with.
Mr. Bolts works for Cartwright King. That's all I'm prepared to say on it.
That's not really an answer as to his abilities.
As I say, there was no other issues with any other the solicitors on my work effort from any other solicitor within Cartwright King. So it can only be Mr. Bolts' opinion.
Who was in charge of deciding whether to retrieve audit data?
It would come as a request. Sometimes you may do it to identify something.
Who do you see as being ultimately responsible for requesting the underlying audit data in this case?
It depends on the inquiry. When you're looking at the inquiry of sort of to try and establish something, you may order the ARQ data via the casework team, or you may be requested from the solicitors as the defence require the ARQ data. It's a two-way street. It could be either party.
In this particular case, who do you see as having responsibility for taking the decision as to whether the data was requested or not?
Well, without the file, I can't say for certain whether the data was ordered or not.
Well, the email there is very clearly, Mr. Jenkins said, I can carry out more of an investigation. The decision has been taken not to carry out that further investigation.
And that's what the email implies, but I will have discussed that with Mr. Bolts.
And who is responsible for the ultimate decision?
Mr. Bolts. He's the one putting the evidence together for the defence, for answers for the defence.
Can we please look at poll 00089381, please? This is the statement from Gareth Jenkins that was put forward in that case. I'm going to read to you from the first paragraph. It says, "I am Gareth Idris Jenkins. I am employed by Fujitsu Services Limited, who have been contacted by Post Office Limited to provide the Horizon systems operating in post offices around the country. However, I understand that my role is to assist the court rather than to represent the views of my employers or Post Office Limited." If we go over the page, please, I'm going to read some of that statement. He says, "I've been asked to provide a statement in the case of Grant Allen. I understand that the integrity of the system has been questioned, and this report provides some general information regarding the integrity of Horizon. I note that in the summary of facts, it is stated that during the period of relocation in March 2010, that Mr. Allen believed that a £3,000 discrepancy was due to Horizon not sending out data, non-polling. I have been shown extracts from the Horizon non-polled reports for the period the 8th to the 17th of March, which shows that the Winsford branch was included in the report for 12 days up to and including the 17th of March. This in itself is unusual, as if a branch appears on the non-polled report for more than a few days, an attempt is made to retrieve the data by other means before day 10. I have no knowledge as to whether this occurred in this case or not. This confirms the fact that there were indeed communications issues between Horizon and the data centre at this time. However, it should have had no impact on data recorded locally within the branch, provided all operational processes are followed correctly. Also, once communications were restored, all historical data should have been sent from the branch back to the data centre as normal. I have not had an opportunity to examine the detailed logs from the period to see whether there were any issues and any justification in the claim that this resulted in apparent system losses of £3,000 as claimed. Now, those final words in that final sentence, I have not had the opportunity to examine the detailed logs. Do you consider that to be a fair and accurate statement of the position that we've seen from those emails?
It looks that way, and that goes back by the previous document you showed, that whoever made the decision has come to not to ask Mr. Jenkins to look at it. But my stance still stays the same, that if money is required to sort something out, it's paid.
Do you think it's important to have a fair and accurate witness statement produced in criminal proceedings?
Of course it is.
And is your view that Mr. Jenkins didn't have the opportunity to examine the detailed logs? Do you think that's a fair and accurate description?
Based on the email from Mr. Bolts, yes.
It is a fair description.
Based on the first email, Mr. Jenkins should have been given the opportunity, if it was required, to examine further data.
Because there was the opportunity present, it just wasn't taken up.
Based on the email, yes, you're correct.
Can we please look at the very final page of this witness statement? He ends the statement by saying, I've been involved personally in a number of challenges to the integrity of the original Horizon system and produced witness statements for a number of cases where the integrity has been challenged. I'm not aware of any cases where the integrity of Horizon Online has yet been successfully challenged in court. Just pausing there, that's very similar to the wording of your statement that we looked at the very beginning of today in terms of not being aware of any successful challenges in court. Were you or anybody in your team involved in the drafting of this witness statement?
No, not at all.
The main challenges in the cases where I've been involved were presented as hypothetical issues, and my previous witness statements went through each of these hypotheses and showed that there was no specific evidence for any of them in the data presented. In summary, I would conclude by saying that I fully believe that Horizon will accurately record all data that is submitted to it and correctly account for it. However, I cannot compensate for any data that is incorrectly input into it as a result of human error, lack of training, or fraud, and nor can any other system. Can we please turn to POL 0008965, please? This is your post-conviction report. I think you drafted this report.
It's what's known as the final report. It's trying to summarise fully what had happened in the court.
Thank you. If we scroll down, it explains that Mr. Allen had previously indicated that he would be willing to plead guilty on the basis that he cannot account for the loss, but admits covering it up. And it says that Jarnail Singh considered that to be an acceptable plea. We then scroll down to the bottom, and it says no costs or compensation was ordered as the defendant was due to declare himself bankrupt. There is a loss of £11,705 to Post Office Limited, and the civil route should be considered to recover the outstanding amount. Having not considered the underlying data in this particular case, how could you be satisfied that there was an actual loss of £11,705?
That, again, without going through all that data, at the time, that's what it's done. And that last sort of paragraph, normally the judge, when someone up would sort of, when you're asked for costs, would normally say any outstanding thing to be done by the civil route. So Mr. Allen admitted there was a shortfall, where the part in question is where the loss come from. But he admitted it because he told the auditors right at the beginning it's going to be £10,000 out, and that's where that's come from.
And the basis of his plea, as we've just seen, was that he couldn't account for the loss, but he admits covering it up. So his admission was, I covered it up, I don't know how it happened. How could you be satisfied that in fact that money had been lost and wasn't just simply a paper loss?
At the time, we were told, as you've said on numerous occasions, while he was for the Horizon, we're told, as Mr. Jenkins said in his statement, that the system was okay. 100% you couldn't, based on certainly what's known now, and sort of thing, that it's a paper loss. But also, whatever cash is in the post office would still always be there.
I'm going to move on to the case of Noel Thomas, please. And that can be found at Pol 00113278. And we're looking at paragraphs 149 to 155. I'm afraid I don't have the page number. I think Mr. Thomas's case, I think you assisted Diane Matthews in that investigation.
Correct.
I'll read briefly from the Court of Appeal's judgment. They say Hughie Thomas worked as a postman between 1965 and 1992. He became a sub-postmaster in 1994. On the 29th of September 2006, he pleaded guilty to 1 count of false accounting. Mr. Thomas's written basis of plea stated that no blame was attached to Horizon and that he accepted there was a shortage which he was contractually obliged to make good, but he did not know how it had come about. The Post Office accepts that this was an unexplained shortfall case and that evidence from Horizon was essential to Mr. Thomas's case. Mr. Thomas has stated that he was having problems with Horizon. In particular, his online banking reports showed several transactions with a nil amount. These were occasions when he paid money to a customer, but the system did not record the value of that transaction. This led to losses, so he altered the cash on hand figures in order to balance the accounts. In his interview under caution, Mr. Thomas said that the alleged loss was due to mistakes on Horizon and that he did not understand the system. He had made 13 calls to the Horizon help desk. It says, although some ARQ, that's Fujitsu audit data, was obtained, it was a dip sample and it was only checked for evidence of 0 transactions. The data was not checked for bugs, errors or defects or for evidence of theft. The prosecution produced a witness statement from Mr. Jenkins explaining that the Horizon system and producing some ARQ data. Mr. Jenkins produced 3 schedules from that data to explain the 0 transactions were normal occurrences. The next paragraph, paragraph 152, they say, these factors are sufficient for the court to quash Mr. Thomas's conviction on both grounds 1 and 2. We were, however, presented with further information which bolsters our conclusion that Mr. Thomas's prosecution should not have been brought and which forms the basis of the Post Office's concession under ground 2. An attendance note written by a Post Office prosecution lawyer on the case recorded a conversation with an external solicitor. The note is dated 25th of September 2006, 4 days before Mr. Thomas entered his plea at the Crown Court on the basis that Horizon was not to blame for the shortage. Now, it records, "We discussed whether he should plead guilty to false accounting. I mentioned instructions that we would proceed with false accounting provided the defendant accepts that the Horizon system was working perfectly. Further instructions are that some money should be repaid and could inform Jack that some agreements should be reached taking into account the above instructions. As the Post Office accepts, there was no justification for imposing such a condition before accepting Mr. Thomas's plea." And then it continues on paragraph 155. "In our judgment, these additional factors are themselves bound to bring the justice system into disrepute, providing further strong reasons to allow the appeal under ground 2. Was it, in your experience, unusual for the Post Office to offer a plea on the basis that the defendant had to accept that the Horizon system was working perfectly?
I believe it has happened in this case as well, but normally the prosecution and defence barristers normally speaks on normally when you might have the two charges, basically always theft or false accounting, and you may get the answer they're willing to plead to false accounting, not to theft, and instructions will be taken from the Post Office solicitors and it's accepted. But I think that's the angle they went down round about that time with the issues regarding Horizon.
In your experience, were there circumstances where the Post Office, in order to accept a plea, said that the defendant had to accept that the Horizon system was working?
As I said, I believe it has happened.
And has it happened in a case that you were involved in?
I can't say for definite that it has, sort of thing. But on Mr. Thomas's, during his interview, he did say he didn't like the Horizon system because he kept getting error notices, which indicated he was actually making the error rather than it being the system. And that could be a reason why they may have gone down that line.
Can we please look at poll 000179903? This is a different case of Catherine Jane McHugh. Were you the officer in that case?
Correct.
You're named, I think, as disclosure officer on the schedule. I think you were the interviewing officer as well in that
Yes.
particular case. I'm going to read from this memo. Memo has your name at the top, sent to you by the principal lawyer. It says the above case was heard in Carlisle Crown Court when the matter was listed for trial. Prior to the case being called on, there was some discussions between all parties with a view to establishing whether or not the pleas offered by the defence would be acceptable. An indication was given that a plea to count 2 fraud might be acceptable so long as the defendant stipulated in her basis of plea that there was nothing wrong with Horizon and that she was responsible for the loss and recognised the confiscation would be sought should the loss not be repaid. In the afternoon, the matter was called on and the indictment was put again to the defendant. She pleaded guilty to the charge of fraud, accepting that there was nothing wrong with Horizon and that she was responsible for the loss. Now, just pausing there, there's nothing there suggesting that this came from the defence. This is, it seems clear, doesn't it, from this memo that it was...
It looks that way, but again, at the time, the defence and the prosecution would be talking. It's one part of, it's not the full story, so to say, of what's happening on the day in court.
And do you think it's appropriate for the Post Office to say to a defendant that we might accept the second count on the indictment as long as the defendant, in their basis of plea, recognises that there's nothing wrong with Horizon?
It may well be taken because of whatever was said during the interview, and I believe...
just answer Mr. Blake's question.
I'm trying to, Mr. Williams.
But it's a simple question. Yeah. Is it appropriate for someone representing the Post Office to say, we will accept you a plea, but only if you don't blame Horizon?
Probably not.
Thank you.
And this was the case where you were the investigator and the officer in the case.
And as I was trying to explain, there was also a defence expert that they put in, and that would have been part of the discussion within the court as well, whatever the defence expert case has said.
It may have been something that was accepted, but I think your evidence is you accept that it would not be appropriate for the Post Office to make that condition in the first place.
And certainly with today's knowledge, no.
With today, well, what about the knowledge you had then? I mean, that
Well,
2011.
As I said earlier, that's the way some of the cases were going, that because of whether the instructions come from the solicitors, and that's why, because that's true.
Whose idea was it? We've seen it now in two cases.
Yeah,
So
it wasn't
Noel
mine.
Thomas, we have it. We have it in Miss McHugh's
It wasn't
case.
mine. No, Noel Thomas. I was the second officer, so I had very little before and afterwards dealing with Mr. Thomas. So that's done by the other officer, and this is what's coming out from our solicitors.
Lawyers obtain instructions from their client on the whole. Was the Post Office providing instructions to the lawyers in this respect? Where was this coming from?
As I explained, the investigator will put all the papers together and send it sort of off to the lawyers. The lawyers made the bulk of every decision. That would sort of come back to us. We wouldn't say, oh yeah, we'll have the play as long as they say this or say that. That would be decided at an higher level than me, and that's where it comes from, whether it's Mr. Singh in charge or any of the other lawyers.
Can we look at poll 000136661, please? This is Ms. McHugh's interview. You were, in fact, the interviewing officer, so at that stage you were the main officer, is that right?
The inquiry was assigned to me, yes.
If we scroll down, she didn't have a lawyer present, but she had, I think, a friend from the National Federation of Sub-Postmasters. Could we go over the page, please? It says, Mrs. McHugh was asked to explain... Sorry, I've just lost it now. Was asked to explain further the losses at the branch, as she had only been inflating the cash to cover the losses since August 2008. Ms. McHugh said that she had losses at the time. She did not know what was causing the losses. It says, I haven't taken it as far as I'm concerned. I don't think the staff have. Mrs. McHugh had kept the losses to herself and not informed staff. She thought they were errors and would come back. If we scroll down, it says, Mrs. McHugh said she had not felt 100% with the Horizon system. You were aware at the time that central to her defence was the Horizon system, issues with the Horizon system.
Yes.
Yes. And did that impact in any way on your thinking about whether it was appropriate or not to ensure that any plea was on a basis that the Horizon system was working perfectly?
Of course it does, and as I say, I reported the facts of the interview and then inquiries made to the criminal law team.
Could we look at poll 001412225, please? Thank you. Could we scroll down to page 5, please? If we could scroll down to the bottom email, we have an email from Andrew Daly to a number of people, including yourself. And if we keep on scrolling down, it relates to duplication of transaction records in the Fujitsu audit ARQ returns. And can you see there that there is an email about concerns that there may be duplication of transaction records in certain ARQ returns? And if we scroll down over the page, we have the Rinkfield post office, which is Miss McHugh's post office. This was the year before the plea was accepted on the basis that there was nothing wrong with Horizon. Do you recall being informed that there might be
Well,
issues with the duplication of
If,
transactions?
if it's sort of in there, but I'm sure that the ARQ data was obtained for Inkfield.
Yes, and the issue here is where it is obtained, there may be a problem with the actual data itself.
But the data would have been looked at to see whether these are duplicate data in there, because the transaction would show the same. You would have two perfectly sort of, say, a cash withdrawal with the same number and the same number at the same time.
And knowing this is 2010, so quite a bit of time before that plea was accepted, knowing that these kinds of issues can arise even with audit data, in her case and in Noel Thomas's case, do you think that it was appropriate for the Post Office to be insisting on conditional pleas on the basis that there was nothing wrong with the system?
Probably not, no.
So I'd say about 15 more minutes of questions before we move on to questions from call participants. We usually have an afternoon break at around this time.
Yeah. And can I get some idea of the participation of the co-participants, if I can put it in that way? Mr. Steen, are you going to ask some questions, or Mr. Jacobs?
So it will be me today. I think probably 10 minutes.
All right, that's fine. Mr. The pillar is intervening.
Same, sir.
Same. Mr. Henry or Ms. Page?
15 minutes.
Right, okay. Good. Well, on anyone else, I should say, I've looked at the...
I think
Right, thank
Mr.
you.
No.
So that's, on my calculation, 35 minutes.
Yes.
And what's the time now?
It's now 3:20.
So we will have a 10-minute break, and then I will hold each of you to your time estimates. So you first, 15 minutes, Mr. Blake, then Mr. Jacobs, 10, then 10 for you, and 15 for Mr. Henry. And that will be it.
In fact, it was agreed between the parties that I would go first on this occasion.
Well, that's even more reason to hold you to 15 then, isn't it, Mr. Henry? Very good. I'll see you in 10 minutes.
Thank you, Mr. Bradshaw. I'm going to move on from the case studies and look at some contemporaneous complaints that were made by some sub-postmasters. Can we please look at poll 00108851, please? And it's page 52. This is a letter to yourself that was ultimately exhibited in a county court case of Asfar Saeed. Do you recall?
I recall the name.
If we could please look at if we could scroll down. So it's for your attention, dear Mr. Bradshaw, and Mr. Saeed has produced what's called a record of investigation. And if we scroll down, it is essentially a complaint from him. And if we scroll down further, we see he says, the document investigation is a document of history of events and chain of activities carried out and conducted by the investigators known as Mr. Steve Bradshaw. He doesn't know the name of the person from Royal Mail. And over the page, he says, Miss Diane, presumably that's Diane Matthews. Or was there another Diane who you worked with?
It's probably Diane Matthews.
He says, this document is based on unpleasant experience, inappropriate exercise, and improper conduct of practice, unbearable attitude, harassment, and victimization, bully faced by Mr. Saeed and the family during the unfair and undue suspension and investigation process. Could we turn over to page 57, which is where the substance of the allegation is? It's the second half of the page. He says, I entered into the house Mr. Bradshaw, with one of his lady colleague called Diane, was waiting for me. Steve Bradshaw stood up, shook the hands. Mr. Bradshaw showed me his identity, offered for them to be seated. He pulled out some forms from a file he had and asked me to sign. The forms were not ordinary, they were legal forms, consent to search my house. Mr. Bradshaw told me they came to search my house, whether I stashed money, post office paperwork, or financial documents. I was astonished and very unhappy and reluctant. Mr. Bradshaw threatened me if I do not consent, they'll call the police, who arrest DNA, detain me and ruin my house by digging and lifting floorboards. I entered the house. Mr. Bradshaw, with one of his lady colleague called Diane, was waiting for... I was confused, lost, and very disappointed. However, consent. In the meantime, Mr. Bradshaw called his third colleague waiting outside in the car. I let them to carry out the search. My house, my car was fully searched. I think that says, in fact, I assist. And the areas where even they didn't want to, after an hour and 15 minutes search, nothing was found. Some financial details of my bank accounts were noted. If we go over the page, please, towards the bottom of the next page. He says, because the discrepancy would not exist physically, no cash was over or short, so both were left unresolved, transfer into local suspense. I represent the training book. He says, since then, Chesterfield Helpline and trainer were notified and involved to clear the discrepancy error, and the process was arranged by the training department, etc. Over the page, he says, after detailed dialogue and analysis, some documents prepared by Mr. Steve, I think that's a reference to yourself, the discrepancy was found quite unrealistic and absolutely unnatural. He says, during the interview, Mr. Bradshaw stressed, shouted, and tried to put words into my mouth that I stole the money. That was very offensive and unacceptable, but I replied and rejected his attempts to make me take the words and answer no, never. If we could go to page 64, about halfway down the page of 64. He said, as I've already said repeatedly and reiterate again and again, from the day one of the problem raised, that the discrepancy shortage is a genuine paperwork mistake, remittances, computer error, or human error by staff. Moving on to another letter, it's UKGI 000148839. Thank you very much. This is a letter sent in 2009 from a Katie Noblet. I believe she was the sub-postmistress in Preston in Lancashire. She says as follows, I'll just read half of this letter. It says, I write to complain about the unprofessional, disgusting behaviour and actions of two of your employees, these being Caroline Richards, a business development manager in Lancashire, and Steve Bradshaw, a post office investigator. The post office I work for is under investigation. I'm now working all hours there. I received a phone call from Steve Bradshaw asking me to make a statement. He wanted my mobile phone number, but I don't use it for work. He asked me if I had any free time, free during working hours, which I replied, no, as I'm working. I asked if giving the statement was something I had to do. He said no, but it could get me in the clear. He phoned again the same day, wanting to know if he could meet me to take a statement. I haven't decided and wanted to seek legal advice, so I told him I needed to think about it. The following day, Mr. Bradshaw and Miss Richards came to my place of work and asked if I wanted to make a statement. Without introducing himself, I told them I didn't know because I hadn't had a chance to seek legal advice in under 24 hours when I worked 9 to 5, 6 days a week. I found Steve very confrontational. I told Steve that I wouldn't make a statement without legal representation, and he told me that I wasn't allowed one, which is a complete lie. She says, after a very confrontational 5 minutes, and after Steve didn't get what he wanted, Steve told Caroline to close the post office, which is not his authority to do. As I understand, Steve and Caroline left the store. Now, as I say, these aren't case studies. We haven't looked into these cases at all or in any depth whatsoever. But can you assist us with why it is that your name seems to crop up again and again?
I can't understand because they're not totally accurate. Certainly Mr. Saeed, he would have been informed. The forms would have been explained to him over the phone and we would have arranged to go and meet him. The business at the time asked us to ask people for a voluntary search of their home address, and that's what that was for before an interview. It was always a requirement of 3 people to do a search if possible. And that was due to an investigator in the past who was shot and killed while undertaking a search. So there was always, where possible, there was always 3 people.
Simply reflecting on the evidence that we've been through today, from the interviews that we've looked at, looking at these letters, do you think that you might not have been quite as professional as you think?
No, I don't think that's all. I will stand. My stance is they're taken out of context.
I'm going to move on to a few miscellaneous topics, some of which have been raised by call participants. The first is contact with Gareth Jenkins. Could we please look at FUJ 00122938, please? And it's page 7 of that document. At the bottom of page 7, we have an email from yourself to Gareth Jenkins. And you say, Gareth, can you please see the attached report, and our criminal law team ask you to consider the report and let us have your initial views as to the contents of the report and also your comments on the disclosure. If we scroll up, we have his response. He says, I'm not aware of this case, but when I spoke to Charles McLachlan, who is and he's put defence experts and speech marks for a number of cases. Last week I did mention that he was now involved in a case in Cumbria, so perhaps this is it. We then have an email on the previous page, page 6, from Penny Thomas, and it seems to be a bit of a telling off from Penny Thomas to you. If we scroll up, she says as follows. So if we could scroll up slightly. Steve, your request to Gareth Jenkins and his response to you have been copied to me. Please be aware that it is against process for investigators to approach Fujitsu employees direct for assistance with litigation issues. Please direct all your requests via Jane Owen or her team at Salford. Can you assist us? First of all, in terms of Gareth Jenkins, I think you said in your witness statement that you didn't really recall any.
That's one of the maybe once, twice maximum. There is another email from Penny Thomas who explains why I contacted Gareth Jenkins direct, and that was at the request of the criminal law team. Normally, everything would be done via Jane Owen and her team in Salford. This is an exception of why it's done, and there is an email from Penny Thomas that explains why I done it.
Yes, and that's higher up in this chain.
Correct, yeah.
Can you assist us? What was your knowledge of Penny Thomas's role?
Penny Thomas has something to do with the prosecution part of Fujitsu. I never spoke to her a few times.
And what did you understand the problem to be with investigators contacting Mr. Jenkins directly?
I don't know what they put a process in that we were to go via the casework team for any they were the engagement. The casework team had the engagement with Fujitsu, probably to stop every investigator bombarding them with what's required.
Do you think that you had enough contact with Fujitsu?
As I said, all contact with Fujitsu was always via the casework team. Anything that was required would go via the casework team.
Thank you. If we go, please, to FUJ 00122939, please. We have there some comments that Mr. Jenkins made. He says, I've been asked to comment on the expert witness report produced by Charles McLachlan in the case of Catherine McHugh, associated with Rinkfield. Could we all bring onto screen, please, your statement, page 5, paragraph 10, so your first statement. So that's WITN 044500100. And it's page 5, paragraph 10. You say as follows in relation to Gareth Jenkins. You say, I did not know that Gareth Jenkins was considered to be an expert witness. My understanding of an expert witness is a person who has greater knowledge in their particular field than the ordinary person. I may have spoken with him when at the same court, but I do not recall having any discussions with him regarding his role. Had you received any training in relation to the role of an expert?
I can't recall any training to expert witness. I think Mr. Jenkins was considered by the business to be an expert witness. And as I say, all requests went via the casework team for anything from Fujitsu.
And you said that my understanding of an expert witness is a person who has greater knowledge. Is that still...
I would say that, yeah, if somebody had more knowledge of a particular field than somebody else would be considered an expert.
Mr. Bradshaw, you're still employed by the Post Office in the security team. You have had a career that spans all of the issues that we have discussed, including the Bates litigation, including the Hamilton appeals. Do you think it's surprising that you don't have a greater understanding of the role of an expert in proceedings?
As I say, Mr. Jenkins has the business had them down as Fujitsu's expert witness. My understanding, and I'll still stick by it, is a person who knows more in that particular field than the ordinary man.
But do you not think that, given everything that's happened at the Post Office, you perhaps should familiarise yourself a little bit better with what the role of an expert witness
Maybe,
is?
but as I say, considering investigation-wise, we haven't done anything for 10 years. I haven't. The last time I will have any investigation through to prosecution is probably sometime between January or July 2014.
Do you think it is unfortunate that at that time you were not aware of what the role involved?
With hindsight, yes, of course it is. You know, there's always a learning process.
Can we please look at poll 0032361, please? This is an email from Andrew Bolts to myself in relation to Chris Bramwell's case. If we could look at the final paragraph there, he says, with regard to your statement, which is in effect being treated as an expert report about the Horizon system, the judge has directed that you are to liaise with Mr. Jenner, the author of the defence report, in the usual way between experts to identify the issues of disagreement between you. So you had written a statement in this particular case that was in effect being treated as an expert's report. Is that right?
It depends on which statement it is, because I do recall seeing a statement when I said I am not an expert, and I've clarified whatever the statement is. So whatever this statement is, I would need to say it first before sort of seeing it, or they've taken the statement when I explained what we explained earlier about the workings, the actual hardcore machine, you know, the screen, etc., and if it's working correctly, what happens about transaction from start to finish. Now, if they're taking that as being an expert, I am no expert. I have a working knowledge of Horizon, but I am certainly not an expert.
Do you think it is a little odd, perhaps, that you're being described as being treated as, in effect, an expert, and haven't had any kind of discussion with anybody as to the role of an expert?
Completely, and as I said, in one of the statements where they've got me down as an expert, the beginning of the statement says I am not an expert.
In terms of your training more generally, can you assist us? Did you have any qualifications, whether it relates to giving expert evidence or if it relates to...
It's certainly not for giving expert evidence, no.
And how about carrying out investigations?
I've done the courses, and I've done advanced interviewing courses, both with the method search courses with the Thames Valley Police, advanced interviewing by the Metropolitan Police. Attended them type of courses over the period of time, and Cartwright King used to have sessions where they go through whatever's there.
We heard at the very beginning about your progression from telegraph officer, television inquiry officer, up to the security team. Do you think that you were provided with sufficient training and qualifications?
I think at the time we went sort of, you know, for each role, the training has been, when I took the role as the security and investigation manager, it was done by Royal Mail Group trainers. And there was a course with past marks that had to go.
Do you think it was sufficient?
At the time, I had no reason not to think it wasn't sufficient for starting.
And what do you think now?
It still covers more. I've always said there's always opportunities to learn more. So from there, if that wasn't considered sufficient, maybe it should be a 3-week or a 4-week course with extra added on.
And how many weeks do you think you have been trained on things like disclosure?
As I say, over the period of time, there's always been the odd day or 2 days seminars where you've gone through.
Thank you. I'm going to move on to...
Well, Mr. Blake, you've had a generous 15 minutes, and I think to be
Well-
fair to those that are following you, unless it's something critical, and I mean critical, I think we can hand over to the CPs now.
So I'm certainly happy. There are only questions from call participants themselves, so should they have any questions that arise?
I'll be the arbiter now of what's critical or not, and that includes you and them. So I say you stop and someone starts. Mr. Henry.
Sir. Mr. Bradshaw, contrary to what you say, you and your department, the security department, were drenched in information that Horizon wasn't working from the very beginning.
The information come through, yes.
And that information came from scores and scores and ultimately hundreds and hundreds of innocent sub-postmasters who were suffering an epidemic of shortfalls.
Yes.
It came from what they told you, but even before that, it came from the thousands of calls they made to the help desk at the National Business Support Centre. And you would have been aware of those calls, wouldn't you?
Not all of them. If we've been with calls made, it all depends on which inquiry. You know, what inquiry are we talking about at the moment?
Well, I'm talking about the thousands upon thousands of calls, anguished and perplexed calls, made by sub-postmasters that they could not balance, that the system didn't balance. And your department would obviously have to have been communicating with the MBSC and also the Horizon Help Desk.
They would have been call logs would have been requested from them to see what issues were raised.
You have to communicate with that department because integral to your duties in the security department was the enforcement of the contractual duties of sub-postmasters, wasn't it?
The call logs would have been accepted, it would have been requested, and there's nothing on the call logs to indicate that there was any issues with Horizon. I would not be communicating with the MBSC team all the time over that. That's their role.
But you would have obtained, surely, as part of your investigations, the call logs.
That's right, and the call logs would have been interrogated to see what issue was there. And a lot of the time you would see call logs where they're showing about how would you do it, passport, DVLA, disc, etc. Anything that would relating to Horizon would be further interrogated.
You say that?
Yes.
You and your department, I suggest, on the contrary, ignored anything that didn't fit the narrative that Horizon was working.
That's your suggestion.
Time and time again, when somebody ended up under your gaze, each solitary, quite often terrified sub-postmaster sitting across an interview desk from you or one of your team would have been told that they were the only ones with a problem. Isn't that right?
No, that's not correct at all. I don't know where that's saying the only one is right. As explained earlier, depending on the branch, as one of the examples given, is that person was the only one in that branch that had any issues. I don't know, I've never said that to anybody. I've interviewed that, you're the only one that has this issue. I have never said that, and I will stick to that.
And what I'm going to suggest as well, that you claim that you weren't getting the messaging from the top, that you were, as it were, not getting any information fed to you about unreliability with Horizon from the top. But that isn't right either, is it, Mr. Bradshaw?
That's correct, yeah. I was not aware of any bugs, errors or defects. They'd come down to it, but nobody sort of said anything. Second site was put in, and the message was that once they put a subject matter expert in, everything will be back to normal. That come from the top. Top down, not bottom up.
By 2012, when you were either giving or prepared to give expert evidence, Mr. Bradshaw, the problems with Horizon were obvious, weren't they?
I've said before, and I will say it again, I am not an expert on the Horizon system.
The lawyers may have written your statement, but you signed it, Mr. Bradshaw, didn't you?
That was one statement about the Horizon issue that is approved, that come from the business.
And you would have been aware, surely, of the pressure building up from the 2009 Computer Weekly article by Rebecca Thompson.
I seen sight of it, but I didn't follow the Computer Weekly.
That MPs then became involved, inquiring about their sub-postmaster constituents and parliamentary questions, mounting pressure. You would have been aware of all of that by the time you signed that statement.
As I said, that statement come from the business.
And you would have been aware, of course, by that time, and you've already mentioned them, Second Sight. So, again, Mr. Bradshaw, I ask you to reflect very carefully on this, because I don't want to have to put to you something which I haven't put to any other witness before in this inquiry. But it is obvious that you would have received briefings from those above you. Whether they still exist or not remains to be seen. But you would have received briefings from those above you that it was going to be business as usual. Keep prosecuting. Don't admit anything.
Prosecution stopped, and once the subject matter expert, they were relying on a subject matter expert to come down. And he said once the subject matter expert had done his part, that they expected it to go back to normal. But that never materialised.
Right. Janet Skinner, who sits beside me, whom you interviewed together with your colleague Diane Matthews, she made 116 calls to the NBSC about Horizon. You heard that when Mr. Blake was questioning you today.
Yeah, and I also said to Mr. Blake, I had limited input into that. I was there on the day of the interview, well, Miss Matthews would have had the pre-interview, and post, she dealt with everything there. I was there on the day. So anything to do with calls and everything would have been done by Miss Matthews.
So you had absolutely nothing at all to do with the investigation?
I was there on the day. I didn't do any of the pre-work or the post-work. That will be done by Miss Matthews.
Right. The Court of Appeal Criminal Division pronounced, when clearing Mrs. Skinner of any wrongdoing, that there had been an extraordinary failure to investigate the 116 calls she made to the NBSC in a relatively short space of time. You didn't look, did you, Mr. Bradshaw?
I personally didn't, because the inquiry was Miss Matthews. I was there on the day of the interview.
Mrs. Skinner was persuaded by her lawyer to plead guilty to false accounting in return for the theft charges being dropped, and was advised that she wouldn't go to prison if she pleaded to false accounting, but was jailed for 9 months immediate custody. Now, you've heard the catalogue of failures that Mr. Blake put to you. The woman who sits beside me, completely innocent of any wrongdoing, goes to prison for 9 months. Do you have anything to say to her?
As I said, Miss Matthews was the one who dealt with that thing. If Mr. Skinner has been dealt a wrong road, that is completely wrong. But I had very little input into the case.
Diane Matthews, your colleague, didn't think there was a case on theft. She'd have discussed that with you, wouldn't she?
Not necessarily, no.
She didn't think that Janet Skinner had stolen anything at all, and was of the clear view that there was no evidence of theft. Are you saying that she would not have discussed that with you?
No, she would have reported that to the criminal law team. It was Miss Matthews' inquiry. Everything was done. I had little input into that inquiry. I was there on the day of the interview, but any pre-work or post-work would have been by the person looking after that inquiry.
So you had nothing to do, for example, with endorsing the contents of the report?
No,
Diane Matthews told the inquiry that she was shocked when Janet Skinner was charged with theft. Were you?
as I say, Miss Matthews is the one that sorted it. I just accept whatever the lawyers did. If they put that charge in,
Oh, that you accept what the lawyers do you?
on that particular case, the lawyer, Miss Matthews, looked after that case. I had very little input even afterwards. If I'd known, any charges would have only come when in passing if Matthews had told us.
Juliet McFarlane has been described to this inquiry as a gentle person. Would you agree?
Yes.
So, was she malleable? Were you able to persuade her to do things?
No.
Because theft was a wholly unmeritorious charge, wasn't it?
Of course, but as I can say, Miss Matthews dealt with that inquiry.
Did
I
you
had little
press?
input.
Did you press Juliet McFarlane, Mr. Bradshaw, to charge theft?
No, because I had little input in that inquiry.
So, this gentle person charges theft contrary to the view of the investigating officer who has complete responsibility, according to you, for this investigation. And that decision on theft has nothing to do with you, you say?
Nothing whatsoever.
What I'm going to suggest, Mr. Bradshaw, is that whoever responsibility it was, theft was a nasty jemmy or crowbar to leverage pleas to false accounting, wasn't it?
That's what you suggested. But again, I can only say I had nothing to do with the inquiry. That was done by the other officer who dealt with the lawyers.
But you knew, from a point of view of your long service and your reputation in the security department, that that was a legitimate ploy, wasn't it? Charge theft, a bankrupt charge of theft to squeeze a plea to false accounting. You were aware of that, weren't you?
The lawyers, 9 times out of 10, would have had 2 charges down, theft and false accounting.
Thank you very much, sir.
Thank you, Mr. Henry. Is it going to be Mr. Maloney or Mr. Jacobs?
I'm happy to go.
Fine, yep.
I'm not sure if my microphone's on.
Well, I think everybody wants to hear you, Mr. Jacobs, so...
Maybe I can raise my voice until we start.
Got it.
Thank you. Mr. Bradshaw, I represent 156 sub-postmasters and mistresses, and one of whom is Shazia Sadiq, who sits to my left today. This morning, at about 11:25, Mr. Blake took you to the statement of Jacqueline MacDonald given in the mediation case. Do you recall that?
Yes.
And I don't want to turn it up, but essentially the accusations that Miss MacDonald made against you, she said, Stephen Bradshaw told me I was the only one in this position and that this has never happened before. And she said that after your first visit to her branch, you returned with a lady called Caroline Richards and spoke to Katie Noblet, who was running the branch on their behalf, and you made threats relating to wage deductions and jail time.
That's incorrect.
Now, I know you've denied this.
Yeah, it's incorrect for the simple reason, if you let me explain why it's incorrect, is that when we were going for a statement, as normal, because she worked in the branch, the people running the branch were a firm called Potent Solutions. They're responsible for paying the wages. I have no control to take any wages or deduct any money, or even, and I wouldn't threaten them with any jail.
I have a different question for you.
Okay.
And my question for you is, have you been following this inquiry? Did you watch the sub-postmasters and mistresses and assistants give evidence in the human impact hearings between February and March 2020?
I've seen some of it. I haven't followed it 100%.
Well, Mr. Bradshaw, we act for 156 sub-postmasters, and of those, 49 of them have told us that they were told by the post office, by investigators like yourself and other officials, that they were the only one. 49. And 61 of our clients have told us that they were threatened with prosecution. My question to you is that what Mrs. MacDonald says about you is pretty standard practice in relation to how the post office behaved towards sub.
That's how it sounds like, but when I've done anything, I will... Sorry, can you just go back? Part of it is I've never threatened anybody with prosecution. At the end of any interview, the people being interviewed are informed of the next course of action or next steps. And that is that whoever is the lead investigator would do a report, and that will be sent off to the criminal law team or then Cartwright King, and they make any decisions on the next progression of the case.
I can see what you're saying is that the decision to prosecute wasn't necessarily made by an investigation, it was done by the lawyers. But my question to you, and I'll ask it again, was that do you accept that telling postmasters that they are the only one, and we have 49 clients who say that's what they were told, and telling sub-postmasters that they could be prosecuted or go to prison, and we have 61 clients who said that is how they were treated, that was pretty standard, that was pretty typical, wasn't it?
If people in the post office, investigators, have said that, that's completely wrong. I can categorically say I have never said that to people, that you're the only one.
Well, let's look at your behaviour, shall we? If I could ask to have a document put up on screen, it's the statement of Shazia Sadiq, which is WIT N022300100, and page 13 of 16, starting at paragraph 72. Hope I haven't gone too quickly. And while we're waiting for that to come up on screen, Miss Sadiq was the sub-postmistress of 2 branches in Newcastle. She had to pay over £10,000 of shortfalls, which weren't due to be paid, but she did anyway. The Post Office demanded a further £20,000. She was then a victim of cyber fraud in relation to MoneyGram, and the Post Office wanted to recover nearly £34,000 from her after an audit. And the cyber fraud had also affected 11 other branches, but she wasn't told about that at the time. Do you recall that case?
I'm not sure about cyber fraud. I do remember a case of MoneyGram fraud, and that was when a bogus engineer, is probably the best way to describe it, was phoning branches up saying they would come to test the equipment. Could they just input certain amounts? And when they were putting there in, they were saying, that hasn't worked, try 20,000, that hasn't worked, try 30,000.
Okay.
That was the case that was dealt with by MoneyGram, because their reasons that once you do it, they will make a payment straight away.
Well, let's go to Ms. Sadiq's statement. So at paragraph 72, it's on the screen. She says, after losing my post office, my children and I were abused in the street. I went to the Brighton post office, which had been my home. I was near the entry to my home when a group of men began shouting at me and threatening me and calling me a thief. They threw eggs, flour and stones at me and my children. And then at paragraph 76, just scrolling down, please, she goes on to say, on the evening of the day, the eggs and flour and stone were thrown at me and my children, and I was called a thief. We fled our home with just my children's teddy bears. And then if we could go, please, to paragraph 82. She says, I have received threatening calls to my mobile phone and emails from Stephen Bradshaw and Brian Trotter. Mr. Bradshaw was a post office security officer and Mr. Trotter was a post office contracts manager. And what she says, that, and then she goes on to say, I've received particularly intimidating telephone calls from Stephen Bradshaw, who began calling me before I knew he worked for the post office. He didn't identify himself in his calls, he just made demands of me. Now, what I want to put to you is what you did. You would introduce yourself sometimes. You would say, where has the money gone? Why won't you talk to me? Why won't you meet me at the branch? I've got people who I want to defund the branch. She would find you aggressive and hang up on you, and you would call her back repeatedly, and you called her over 60 times during this period. Is that right? Do you recall that?
I wouldn't say that was completely accurate. The 2 audits, one took place on the 26th of October, one took place on the 27th of October. I called Mrs. Siddiqui on the 4th of November and left a message. I always, on any phone call, always say who I am and leave my mobile number. I called again on the 8th because I hadn't received the call back. On the 10th of November, Mrs. Siddiqui called me because I sent her an email later on with the words, our telephone conversation refers, and on that email, as I explained who it was. And it was about arranging a time or place as per what my contract was as a role to do an interview.
That's not true. You hounded her, didn't you?
No, I didn't.
Well, then let's go to the next paragraph, shall we? Let's go to paragraph 84. Because this is what happened. On the 29th of November 2016 at 13:44, Stephen Bradshaw called me and I refused to speak to him because I didn't know who he was or who he worked for. In that telephone call, which was witnessed by my husband on loudspeaker, he called me a bitch, which I found extremely distressing. That's how you behave towards my client.
Completely untrue. I do not call anybody that type of name. And she did know who it was because she received an email from me on the 10th of November.
You have shown in your evidence today that you are prepared to be aggressive. You tell people in interviews to get up earlier. Other people have described you as very confrontational. This is the way you behaved, isn't it?
That's not correct, no.
Do you accept you behaved unprofessionally?
No.
Do you accept that it was part of the culture within the investigation team to intimidate
No.
and abuse sub-postmasters?
No. A phone call will be made to arrange an interview at a convenient time and date.
Well, let's move to another client, Rita Threlfall. She was the sub-post mistress of the Ford branch in Liverpool from 1998 to 2010. Can we go, please, to another document? It's POL 00107-683. And while we're waiting for that, I'm just going to ask you if you recall her. You interviewed her at the Liverpool North delivery office on the 10th of March 2000.
Right, a working Royal Mail delivery office.
That's right. And you recall that?
I do.
Right, well then perhaps we don't need to go to that document just yet. If we could go to Ms Threlfall's witness statement, and I'm going to ask you about the circumstances of the interview. If we go to WITN 02360100, page 7 of 15, please. And if we go to paragraph 46. Just waiting for it to come up now. So Ms Threlfall is disabled and she's wheelchair dependent. And she says, in August 2010, I had to go for an interview under caution with a post office fraud investigator, Stephen Bradshaw. The interview took place at a post office sorting office in Liverpool. She goes on to say, at paragraph 48, upon arrival, they left my husband and me in a hallway. We asked for a chair and never received one. I ended up having to sit down on the stairs. This is a disabled lady who uses a wheelchair. She goes on to say, at paragraph 49, the interview room was upstairs. I told them there was no way I could make it up the stairs. In order to make it to the interview room, I was placed in a tiny parcel lift. Do you recall that happening?
I recall going in the lift, and that's untrue. It's a Royal Mail delivery office. The chances of being given a chair would be slim because as you walk in the delivery office from outside, you have what's known as the caller's office where members of the public collect the mail. The door facing you is where the sorting office floor is, where all the mail. So you have postmen coming backwards and forwards. During the interview letter, they would have been asked to make themselves known to Royal Mail. That's who it was. Either Royal Mail would have brought them upstairs, Mr. Knight or myself will have come down to collect Miss Threlfall, but it wasn't a small, tiny parcel lift. It's an actual lift, designated wheelchair lift, with the thing that takes 5 people.
Mr. Bradshaw, Rita Threlfall is still shaken by this experience. She's watching today. She suffers, she says in her statement, from crippling anxiety and depression, which arises in large part from the way you treated her. She was too traumatised to give evidence before this inquiry, and Mr. Steen, King's Counsel, who sits to my right, read out these very passages of her evidence on the 23rd of February 2022. The Post Office has not challenged this account. Mr. Bradshaw, this happened. Whether you want to admit it or not, this happened.
It's not a small parcel lift. I can prove it to you now.
Would you still work for the Post Office?
I
don't
do.
You? Would the Post Office put a disabled person in a small parcel lift to attend an interview that had been arranged on a floor which they couldn't access today? Is that current practice?
Prior to the interview, I was not made aware of any special requirements, and I can only keep repeating that it is not a small parcel lift. It's wheelchair accessibility, and I can prove it to you now if you wish.
Well, I have to say, and Rita Threlfall would want me to say that you're not telling the truth, are you?
I've got a photograph here that shows the lift.
We'll move on then.
Well, you've had a generous 10 minutes.
I'm sorry.
If I may say so, Mr. Jacobs, and I know these points are of importance to your clients. but I have to be even-handed amongst everyone. So unless it's critical that you put further questions, can I ask you to come to a close?
I can. I do have a couple of questions, then some very brief questions about Joan Bailey, but I will be very quick, and I have gone on a little longer, and I apologise, sir.
Right? You've got 3 more minutes.
I should be very quick then.
So can I just interrupt just before Mr. Jacobs begins? Can I just say, and it's a matter that's been made clear throughout this inquiry, that evidence given at the human impact hearings has not been challenged because it doesn't hold the same legal weight as perhaps other evidence. There was no need for anybody to challenge.
Well, the truth, although it's cutting into your 3 minutes, Mr. Jacobs, it would have been impossible for challenges in the proper sense to be made of the human impact evidence. I think we all accept that. This is not a trial, it's an inquiry. And I have to make up my mind from hearing competing accounts without sometimes the benefit of adversarial cross-examination as to what I need to make findings about. Because obviously if I would try to make a finding about what happened in every individual case, we will be waiting for a very, very long time for my report.
And I have to say, I do have very firm instructions from my client.
No, I follow, and I understand. Anyway, let's move on now.
So if we could then move to the investigation report, which is at POL 00107-683, page 8 of 9, please. And if we could scroll down to the bottom of that, at page 8 of 9, please. This is the investigation report in relation to Miss Threlfall. And you say in that section, it's page 8, please, sorry. Page 8. I think we'll move on to Joan Bailey, if that's all right. Can I ask you to go to POL 000-57198 and page 4 of 8. This is your investigation report in relation to Joan Bailey, who was the sub-postmistress at the Howie branch. Do you recall her?
Oh, yes.
And you say in that document that can we scroll down, please? You say in the document that Ms. Bailey claimed that she had problems with the system. And if we go to page 5 of 8, you say the merits of the Horizon system were discussed, and it was explained that in a number of court cases the integrity of the Horizon system had been questioned. However, nothing had been proven in court by the expert witnesses, and that any of the discrepancies were the result of failings within the Horizon system. And you go on to say at page 7 of 8, if we could go down, you go on to say Ms. Bailey could not produce evidence to satiate her claim in relation to the Horizon system. So what you're doing is you're looking at a sub-postmistress who has alleged that the shortfalls that she had were to do with the Horizon system and problems and errors in the system. Your response to her is there have been a number of court cases where that has been rejected. So I'm not going to investigate that, and you can't prove that the system wasn't working. That was your approach, wasn't it? You required the sub-postmistress to prove that the system wasn't working.
That response is what come from the business, as has been previously explained on a number of occasions with that statement. That's the business response, what we were told to say.
So
but also to assist me to try and find what issues may be with the Horizon system, I would require somebody to say, for example, if you press the F3 key, this happens or that happens, To just blatantly say it's the system, it's very difficult to try and find the starting point to see what's gone wrong.
Okay, can we scroll down to the conclusion piece? I'm coming to an end, I'm aware, sir, of my time allocation. You give conclusions and you say, whilst a prima facie case for false accounting could be established against Mrs. Bailey, it may be prudent when all the circumstances are considered and the explanation offered by Ms. Bailey at the interview that if all the monies are paid to the post office, then consideration may be given to the issue of a caution in this instant. So what you're saying is, effectively, you took into account all the circumstances, the fact that she'd alleged there were problems with the Horizon system, but she couldn't prove it, and you didn't investigate whether there was a problem with Horizon, and you went to offer, and she was offered a caution simply because you thought she'd made an offer to pay the money back.
No, that was off there. That was put in as an opinion to the lawyers, because there is a prima facie case of false accounting because he covered up a loss. That can't be denied, can it?
Well,
so from
All
there,
right, I've got the point from the document. Thank you, Mr. Jacobs.
Thank
All
you,
right.
sir.
Mr. Maloney.
Mr. Bradshaw, I act for 73 sub-postmasters, all of whom are prosecuted and convicted, and all of whom have had their convictions overturned. I want to ask you about three people, Kaya Mishak, Della Robinson, who sits next to me, and Mrs. Jacqueline MacDonald, all three people in whose investigation you were involved. Kaya Mishak, first of all. This morning, Mr. Blake asked you about the issue of whether sub-postmasters who came after Mr. Ishak, after he was suspended, experienced problems with the Horizon system. Do you remember?
I do.
The post office position was that they had not.
That's correct.
And Mr. Blake took you to a number of documents, and I'm not going to bring up those documents, but I'll remind you of the substance of the questions. Essentially, ultimately, a notice of additional evidence was served on the 15th of February 2013, and that was referred to in a letter from Mr. Smith to the defence saying, we enclose in duplicate copies of a notice of additional evidence the statements of Stephen Bradshaw of the 11th of February 2013 and Abdullah Patel of the 13th of February 2013. Mr. Patel was a sub-postmaster who came after Mr. Ishak.
He came to run the branch, yes.
Yes. And you said that statements had been taken from both sub-postmasters, and the other statement could have been earlier from a man called Learcott. Do you remember?
So, yeah. I do recall that name, and there was a statement from him.
Oh, yes. Now, the opening note for the case only referred to Mr. Patel as well. Mr. Blake showed you that, didn't it? Now, I'm going to try and assist your memory as to who took over after Mr. Ishak, Mr. Bradshaw. There was a Learcott who featured in the case, and he did make a statement, as you say. But that Learcott, do you remember, was Mr. Ishak's assistant in Birkenshaw Post Office?
That was correct, yes.
Absolutely. He wasn't a subsequent sub-postmaster.
No,
Sorry?
the postmaster was Mr. Patel.
Yes.
He was taken on as what was known as the interim postmaster. He was there, and I think he put Mr. Learcott as the officer in charge.
Right, but there were two sub-postmasters, you see, Mr. Bradshaw, weren't there? And I don't want to take time on this, but in an email that Mr. Blake showed you from Mr. Smith to you and counsel Mr. King, it said Steve is in the process of taking statements from the two subsequent sub-postmasters who've not experienced any problems with the Horizon system. You thought that Learcott was a subsequent postmaster. To save time, I'm just going to remind you now, if I may, and try and assist your memory, Mr. Bradshaw, as to subsequent sub-postmasters. The first, there was actually somebody there for a very short time called Mary, whose surname I don't have, I'm afraid, then Mr. Patel. And then the second sub-postmaster was a Mr. Mohammed Sawar. Did you speak to him, Mr. Bradshaw?
Shortly after that, what dates are we on? Because around in 2014...
Between Mr. Bradshaw's suspension and the trial... Sorry, between Mr. Ishak's suspension and the trial, Mr. Bradshaw, because that's what we're concerned with. Did you speak to a Mohammed Sawar between Mr. Ishak's suspension and the trial?
I don't recall speaking to Mr. Sawar. My only recollection is that Mr. Patel was the interim postmaster after when Mr. Ishak stopped being the postmaster. Mr. Patel took over, and what I was saying, Mr. Patel was still in charge, as far as I'm aware, when I went off long-term sick.
Okay, I'd suggest to you that all of the emails suggest that there were two interim sub-postmasters, and it would perhaps be a matter of evidence. But Mr. Patel first, and then Mr. Sarwar. But you did not speak to Mr. Sarwar then,
I
Mr.
don't
Bradshaw.
recall speaking to him, Mr. Sarwar.
Thank you very much. Secondly, Miss Della Robinson. You interviewed Della Robinson. She sits next to me here. You were with Mr. Andrew Wise, and you took the lead. Do you remember it?
I remember Mrs. Robinson. I'm sure that that inquiry, I did interview Mrs. Robinson. I'm sure the person I interviewed Mrs. Robinson with was a Michael Stanway, and a search was conducted by Mr. Wise and Mr. Ryan with Mr. Robinson. They went back to Mrs. Robinson's home address.
And Mr. Ryan sits next to Miss Robinson now. Do you remember him?
From
these events? That's Mr. Ryan.
No.
That's her partner, Mr. Ryan.
No,
of some
so, sorry, the Ryan have got mixed up. It's Kevin Ryan, the security manager.
Anyway,
He went back with Mr. Wise to conduct the search at the home address.
In any event, it was at a Royal Mail office in Salford that you interviewed Mrs. Robinson.
No, it was a post office. It was Salford.
In Salford.
Keys, I think it was called, yeah.
Okay, post office. And when you interviewed her, in Hamilton and others, the Court of Appeal said the following about the interview. In her interview under caution, Mrs. Robinson said that the losses had started about 2 years before. She stated that she and her partner initially made good the losses from their own funds, but as the losses accumulated, this became unsustainable. From around August or September 2010, she instead declared the amounts on the mutilated, i.e. unusable, cash line of the accounts. In her defence statement, she said that any errors or deficiencies were as a result of her difficulties in using Horizon. Now, I just want to ask you one thing about events after the interview, please, Mr. Bradshaw. After the interview, you spoke to Miss Robinson and her partner, Michael, within that building. In a canteen, it may assist you when whether there's nobody else around, but you were sympathetic to Miss Robinson, and you said to her and Michael, her partner, off the record, we know you haven't taken the money, but worst case scenario is that you'll be prosecuted.
No, I wouldn't say anything like that, because it's not my decision.
Right. And then finally, Mrs. Jacqueline MacDonald, and I'd like to take you to your self-appraisal form, one document only to take you to, Mr. Bradshaw, and that is POL 001 65946. It's a document that Mr. Blake took you to this morning. Thank you. Now, Mr. Blake took you to page 5 and asked you about the interests of the business. I want to ask you about page 9, please. And it's where we see, I support, develop and challenge. If we could, thank you very much. I support, develop and challenge. And at number 2, it reads as follows. On the 5th of July 2010, at the court case for, and the reference is given, I challenged their reasoning for accepting only a guilty plea for false accounting and not one for theft. So this refers back to the same case that Mr. Blake was asking you about this morning. I explained the reasons for continuing with a trial for theft. The integrity of the Horizon system was in question, and that problems would occur for future cases. The defendant denied theft, and the money was missing due to the Horizon system. And then this, and if this was accepted, then this argument would give credence to the current campaign by former sub-postmasters. Now, you were very explicit there, Mr. Bradshaw, about your motives in seeking to ensure that no credence was given to the postmasters' campaign, weren't you?
No, that, as I said and then explained earlier, that's a
flamboyant way of explaining what had gone on the day.
Of course, yes.
Sorry. It was a flamboyant way of explaining what had gone on the day.
Yeah.
Yeah. It can't be, can it? Because that is a motivation. It's not a fact. In fact, it's clear from the document that ensuring that no credence was given to the former sub-postmasters campaign was something you were proud of, wasn't it, Mr.
No,
Bradshaw?
it wasn't. As I said, it's a flowering way of putting your one-to-one type notes. Everybody gets PDRs in these days, and I've done for a number of years.
And Jacqueline MacDonald, a mother of no previous convictions, was sentenced to 18 months imprisonment, aged 47, after having no option but to plead guilty to theft after her offer to plead guilty to false accounting was refused on essentially the decision of you, Mr. Bradshaw. You know that, don't you?
Mrs. MacDonald pleaded guilty to false accounting. And then at a later court, they pleaded guilty to theft.
Yeah. Yeah. She wanted to plead guilty to false accounting, and you persuaded them not to accept that plea.
She pleaded guilty to theft.
Yeah.
She pleaded guilty to false accounting first.
Yeah. Thank you very much, Mr. Bradshaw.
Thank you, Mr. Maloney. There's a loose end which I've been mulling over the photograph that Mr. Bradshaw wanted to reduce into evidence. We don't have a situation, Mr. Bradshaw, where I just accept evidence just like that, so to speak. So if you wish to produce that in evidence, the correct procedure would be for you, assisted perhaps by your lawyer, to make a statement explaining precisely when the photograph was taken and matters of that kind. That can be sent to the inquiry, and I will determine whether or not it's accepted in evidence. It won't be accepted in evidence without me giving the opportunity for Mrs. Threlfall herself to consider it, since she has an interest in it. It can then be shown to her, and I will determine thereafter what status, if any, it has. So the ball is in your court, so to speak, as to whether you wish to have this introduced in evidence. So thank you for coming to give evidence, and that concludes a very busy day, I believe, Mr. Blake.
Thank you very much. So
And tomorrow we revert to the thorny issue of disclosure, is that correct?
that's correct. We'll be hearing from Mr. Jackson from Burgess Salmon tomorrow.
Fine. All right, thank you all very much.